Welcome back to the Fostering Financial Victories podcast. My name's Eric. I'm your host. Thanks again for joining us. Today I am joined by Ruth DiPasquale. Did I get that right?
You did.
All
that
right.
was good.
So you're the owner of the Ruth Law Firm here in Greenville.
That's right.
So this is going to be a pretty interesting topic because of the nature of what people go through with probate. So that's the kind of the sense of what we're going to talk about today, and maybe how to kind of avoid some of this.
Sure.
Before we get started, I want to give you a few minutes just to tell everybody how you got to where you are today and kind of what you focus on.
Okay, so I primarily focus on estate planning and probate law at this point. I guess you could say my career has taken various paths to bring me here. Part of the reason that I do that now is I have two small children, and so it allows my schedule to be a lot more flexible. The other part is no offense against litigation attorneys, but I like not having an attorney on the other side. There's less stress in my life because I'm not trying to argue with someone. It's more problem solving. I find that estate planning is like a big puzzle. You get to know the client, you get to know their goals, and then your job is to help them understand the puzzle pieces and help them put the puzzle together. I take it very seriously that my job is to advise, but it's their job to make the decisions. So it's part of giving them the information they need to make appropriate decisions to put together an estate plan and for them to understand it so that they can follow it.
Okay. So professional debaters from a litigation standpoint, is that kind of what it sounds like?
For those that are in litigation, yes.
Okay.
I left my debating days, hopefully in college. I do some probate litigation still, but I think I would call myself a transactional attorney at this point,
Fair
just
enough.
drafting.
Okay. So the probate process, what is it? Why is it there? Kind of give us a landscape on how it kind of looks and how it starts.
Sure. So what I tell all my clients is, first of all, the probate court does not want your assets, and they definitely don't want your children. So the idea that the state's going to take your money and your kids if you don't have a will is not necessarily true.
Okay.
The job of the probate court, very simply, is to oversee the transfer of title. So if I have a car and I die and the car's in my name, nobody can sell that car because nobody can sign for me.
Yeah, because you're dead.
Exactly. So the job of the probate court is to appoint someone who can then sign on behalf of me, and then they're going to oversee where that title is going based on my estate plan if I have a will, or if I don't have a will, then the law is going to tell the court where to send my assets. So all a will does, it doesn't avoid probate, it just tells the probate court where you want your assets to go at death. So the probate court's job is to oversee that transfer of title.
Okay. So that's really clear. Anybody who's gone through this process probably has had a pretty extended experience, meaning that it takes quite a while to go through this. Why does it take so long? If that's simply what they're doing, what's the holdup?
So it takes 8 months to 1 year at best, and I emphasize at best. So the other important thing that I tell my clients is that the probate court is actually a county court. So each county has their own personality. Fortunately, Greenville County is kind of the flagship court for the state. They are very well staffed, and so you will, if you're working directly with the court, the executor, we call them a personal representative in South Carolina, will be assigned a judicial assistant in Greenville County. That means they will work with the same person for the 8-month to 1 year process. That is not true of some of the other counties like Spartanburg, Anderson, or Pickens.
Is that the same kind of across the country? I know that we're in South Carolina, but is it similar?
No, it's pretty different state to state.
Okay.
These are state-specific laws.
Okay.
So there's a lot of people moving here from California right now. Almost everybody in California has a trust because their probate process is very burdensome. Compared to other states, our process actually is not that burdensome. And people laugh when I say this, but you actually do not need an attorney to probate in South Carolina. The court will help free of charge. The only time the court cannot help is if there's conflict or ambiguity. So the whole reason we do an estate plan is to avoid conflict and ambiguity. You pay a little bit now for the estate plan, you save a lot of money later because you don't need an attorney to probate.
Okay, so what type of conflicts would come up in the probate process that would make this a little bit more uncomfortable?
Sure. Challenging a will. So if a family member tries to say that the will was signed under duress or that it's not the most recently dated will, or the other big one is ambiguity. The biggest ambiguities I have seen in my career are when people download wills from the internet. So if you download a will from the internet and you don't understand what you're doing, then a lot of times that results in ambiguity. The court can't resolve that ambiguity without a hearing. And so in order to have a hearing, then attorneys must get involved. So conflict over the will or ambiguity are usually how you end up with an attorney in probate.
And that just makes it go a lot longer.
A lot longer. So back to your other question, it takes 8 months to 1 year because in South Carolina, anybody you owe money to at death has 8 months from the time the estate is opened or 1 year from the date of death to file a claim against your estate. That is why the process is 8 months to 1 year. But I always tell clients a lot of that process is just waiting. It's waiting for that time period to expire. So if I have a credit card through your company, then the day I die, that credit card account gets frozen. You don't continue to charge interest on it. But if my family doesn't open an estate, then the burden is on you as the creditor to come forward and open an estate within 8 months or 1 year. Otherwise, you're forever barred from collecting the money I owed you. So that is why it takes so long. It's because we have to wait out that time period. That actually changed, I believe it was in 2014, where the legislature shifted the burden for those debts from the executor of the estate over to the creditor. If you took the risk of loaning me money, it's on you to protect that now.
Okay. So you mentioned a few different players in this scenario. So the executor, the judicial assistant. Can you give layman's terms on what those people are responsible for doing?
Sure. I always tell people an executor, again, we call them a PR or personal representative in South Carolina, but everybody wants to use the term executor because that's what they read online. So the PR is the person who basically the court appoints to probate the estate. And if you have a will, in the will, you will appoint your PR. And typically the court will accept your nomination unless that person is incapacitated or there's been a change in circumstances. So the PR is the individual who represents the estate, who can sign transfer of title, and who is accountable to the court. The probate process, as long as there's not litigation, is actually a series of filling out forms. So the PR is responsible to fill out those forms and account for the assets of the estate, and then to account that those assets have been transferred in accordance with the will, or if there is no will, in accordance with state law.
Okay.
The judicial assistant is the member of the court, if there is no attorney involved, the member of the court that works with the PR to fill out those forms and to help them account for the assets and to basically tell them how they're going to get that title transferred. And then the creditor, again, is anyone I owe money to at death. It's really any unsecured debt are creditors. So your mortgage company is not a creditor. They can foreclose and protect their debt. RV loans, that's a big one we see. It's not technically a creditor.
That's a very
recreational vehicle. Yeah. They're very protective, and
okay.
they will step in and assert their rights. But they don't have to file a claim because they can just come pick up the RV. Car loans, same thing. They can just come pick up the car. But your credit cards, medical bills, that unsecured debt, they must file a claim against the estate, again, within that time period if they want the claim paid out of the estate.
It's got to be within the first 8 to 12 months.
8 months from the estate being opened or 12 months from the date of death.
Okay.
And so they can't come after family members unless family members co-signed on that debt. So that's a big question I get all the time. Will my family have to pay my debt when I die? No, the creditor's sole claim is to go after your estate in that time period. Otherwise, the legal phrase is they are forever barred.
Okay, so husband, wife, spouse scenario, same?
It is the same. You just have to be careful on credit cards whether a spouse is an authorized user or whether they are actually an owner of the debt. If they are the owner of the debt, then they can go after the spouse if one spouse dies. If they are only an authorized user, they can only go after the estate.
So what makes someone the owner of the debt in the credit card company's eyes?
When you fill out that credit card application, if you actually apply for the credit card in both spouses' name, then you're both debtors on it. Okay. And you'd have to look at the language in the credit card debt. The other option is if I take out the credit card in my name, but I get a card for my spouse just to use, then typically they're just an authorized user.
Okay, that makes sense. So if so let's say someone's been appointed as an executor or a PR and there is no will in place. So, now what?
So if there's no will in place, then we look at the statute to determine who has priority to be executor. So the statute has a list, basically. So my spouse would have the highest priority. If I'm not married at my death but I have kids, they all have equal priority. So again, you talk about litigation. If they don't want to nominate one of them and there's more than one child, then you're going to end up in litigation. If I don't have children and I'm not married, then my parents have equal priority. So there's a very detailed list. There will always be someone who has the ability to serve. Or any of those people can nominate someone to serve on their behalf as well. So the statutes, I like to compare it to landlord-tenant law. If you have a rental property in South Carolina and you fail to sign a lease with your tenant, the law will come in and create a lease for you. It's called the Landlord-Tenant Act. The same thing is true kind of of probate. If you fail to do a will, the law will come in and kind of, in a sense, do a will for you. They will tell you who has the right to serve over your estate and where your estate will go.
Okay. All right. So estate planning is probably a great way to avoid some of this headache.
A great way to avoid headache, but again, a great way to avoid cost. Because you're selecting who is going to serve as executor of the estate, which is going to minimize the chance of litigation over that position. You're deciding where your assets go. You're also signing the will in front of a witness, 2 witnesses and a notary, which is going to minimize the risk that there's going to be a challenge for the will. I don't know that all attorneys do this, but there's a specific will signing ceremony in South Carolina. When I sign a will with my clients, we all sign a document that says we followed that ceremony. The witnesses were in the room at the time the individual signed. I asked them questions to prove they had capacity. The witnesses believe they had capacity. I keep the original of that document so that if anyone does challenge that will, I'm the primary witness at trial, that it was executed properly and that the person had capacity. Again, the goal is to minimize litigation costs down the road.
Okay. What happens if somebody loses a will and can't find it?
Yeah, so I actually had a case very early in my career where the will wasn't lost, it was actually stolen. So
who steals a will?
Well, the safe was stolen.
Okay.
Okay, so the safe was stolen, a police report was filed, the individual knew that their safe was stolen, and chances are the will was in it. 6 years went by, he passed away, never signed a new will. So there's very clear case law now that the minute you know the will is missing, if you do not replace it, it's as though you never had it.
Really?
So he had knowledge that his will was missing. We know that because he filed a police report. So because he didn't move forward to sign a new one, even though we had a copy of the original, the court would not accept the copy because who he left his assets to was different than who the law would have left the assets to. And the presumption is if they had knowledge and didn't replace it, then they intentionally revoked it or canceled it out. So I tell clients there's a lot of benefit in practicing in the age of technology. I keep all my Microsoft Word drafts. There's no reason to delete them. I don't have to do this on a typewriter. So as soon as they find that their will is missing, I have them call me. We just print a new one out and we re-sign. You always want to know where your original will is.
So let me make sure I understand that. So if you lose the will and don't make notice that it was lost and then you die, it's as if nothing was ever documented.
So
even if they have a copy.
If you have to prove that the individual signing the will actually knew that it was missing. So if you can prove they knew that it was missing and then they chose not to replace it, then the court will not accept the copy.
Even if they have a copy. Like
Correct.
if a kid has a copy.
Correct.
Wow.
So an original is very important in South Carolina.
That's a big deal.
I get asked all the time, can we not docu-sign a will? No, you cannot docu-sign a will because the court wants to ensure they have the original because that minimizes the risk that someone has doctored the will, forged a signature. So we actually sign everything in blue ink in my office. I even had the situation once where the court believed it was a color copy and they would not accept that.
Wow.
They will literally lick their finger and see if the ink smears. If it doesn't smear, it's a copy. So they're very serious about having the original will because that tells them that the testator, the person signing it, did not revoke it because it does exist. If the original cannot be located, then there's a presumption that the testator did revoke it. Maybe they destroyed it. So the court does not want to accept a copy unless we could somehow prove that it was lost and the testator didn't know it was lost. But that burden is hard to meet.
Okay. So when families are kind of going into the discussion initially about how they set up all of these documents, where do they start?
So I again, can't speak for other attorneys, but I have always had the impression that having this conversation with clients is like speaking Greek to them. I'm using a lot of terms they don't understand, and even though it's something I do day to day, it's brand new every time I meet a new client. So my practice is the first initial consultation is purely educational. I joke with clients that it's trying to teach a semester of law school in 1 hour. So I'm trying to explain to them the various documents that are available in South Carolina, what they're actually appointing people to do, so that then they can go home and decide, okay, if I'm appointing someone to do this, this is the person I would choose. So I always tell them I don't want answers in that first meeting. I want to give them context so that they can go home and have a good discussion and then decide who they want to appoint. So to me, the first step is really to kind of get that education. And I hate to say this again, but you're not going to get it online. These are state-specific rules, and if you start reading online, you'll quickly get a lot of misinformation. So the key to having an attorney is to getting advice for your specific situation. And that's the other thing. Estate planning, there's not a one-size-fits-all. It's really specific in terms of what the client's goals are, what the client's family makeup is. And so trying to do this yourself online, I typically see ends very badly. Maybe not for you because you've passed away, but it ends very badly for your family.
Okay. So what are some common missteps that people might either overlook unknowingly or just not be aware of?
I will say the most common misstep I see is where we have blended families. So husband and wife both have children from a prior relationship. They get married. They decide to do estate planning. Wife signs a will where she leaves everything to her spouse, but if her spouse dies, she leaves it to her kids. Husband signs a will where he leaves everything to his wife, but if she dies first, he leaves everything to his kids. Well, if you think that the whole way through, either his kids are going to get everything or her kids are going to get everything, but somebody's going to get cut out. And part of our job as attorneys is to anticipate those scenarios and make sure that we are listening to the client's goals and trying to protect the assets and get them where they ultimately want to go. Okay. So there's various mechanisms to do that. But again, I think one of the biggest mistakes is where clients try to do this on their own, and then inevitably someone gets cut out that they didn't intend to.
Okay. So with, we hear a lot of folks talking about the trust document, scenarios. Can you just give some insight as to, basic detail of what does that actually do?
So one of the most important conversations that I have with my client in that first meeting, before we even get to trust, is talking about how property passes at death. Okay. Because you have to understand that even if you have a will, not everything that you own is going to pass in accordance with your will. It depends on how the property is titled. And after doing this for about 10 years, the best analogy I can give my clients is that it's like a baton in a relay race. So when I die, I'm passing off the baton. How it is titled determines how that baton passes. So if I have a vehicle and it is solely in my name, then at the moment of my death, that baton gets passed to the executor of my estate. My estate is going to hold that baton for 8 months to 1 year while they probate my will. Once that probate process is done, they will pass the baton in accordance with my will. So that does not, having it solely in my name does not avoid probate. If I am married and I title my car jointly with my husband, Tony, then we're both holding the baton if I title it with an and. If Tony passes away, I kill a lot of people off, so we'll kill him off. Okay. If Tony passes away, the baton snaps in half. Tony's 50% is going to go through that probate process. I get to keep my 50%
of the car
because it's an and.
You get 2 tires.
Exactly. It's very inefficient. So we really don't like ands. But if you think about it, if Tony were alive, I can't sell the car without his signature because it's an and. He can't sell the car without mine. So it's really 50-50 ownership. We also call that tenants in common. If I title it jointly and it is an or, so Tony or Ruth, then we're both holding the baton. But if one of us dies, they let go. And so if Tony died, he let go of the baton. I'm holding 100% of the baton. None of it goes through probate. So in South Carolina, it's very easy to avoid probate between married spouses if you think about how your property is titled. So vehicles can be an or. Most bank accounts are an or. If we're both on the bank account, I don't need his signature to withdraw more than 50%. I can go in and empty the account out if I wanted to. So with an or, you only need one signature to transfer title, so those avoid the probate process. There's special language in a deed. If you want your house to pass that way, it has to have the phrase joint tenant with right of survivorship and not as tenants in common. So as part of my practice, I pull my client's deed. We see if it has that language. If it doesn't and they want it, then we can certainly correct that. But I've had lots of clients avoid probate just because they've titled things correctly so that when the first spouse passed away, the surviving spouse automatically got everything. Then the fourth one, and this is the most important because these ones pass outside your will, would be if I have a beneficiary. So investment accounts, retirement accounts, life insurance policies, even bank accounts can have beneficiaries. At the moment of my death, I'm passing that baton to the beneficiary. The estate cannot come in and steal it away from the baton. It's an instantaneous transfer at death, even though it's going to take time for the paperwork to catch up. So with those, they're very easy to pass outside the probate court because we just name a beneficiary. The most common mistake I see is people fail to name a backup beneficiary. Okay. So if Tony is my beneficiary, we both die in a car accident. If I didn't name a backup, now those assets are going to have to go through the estate. So it's important to have a primary and contingent beneficiary on those policies. So what a trust does, a trust creates a cardboard box. So what we're trying to do, if we have a joint trust, if Tony and I have a joint trust, we've created a cardboard box where we can both benefit from it. We can both put batons in it. It doesn't really change our day-to-day finances, but we retitle all of our batons in the name of that box, or we make the box the beneficiary. So beneficiary on our bank accounts, we might put our house in the box, our vehicles in the box. The box will continue to exist at my death. So those batons don't have to go through the court to be retitled. We've appointed a successor trustee if both of us pass away to manage that box. And then we've got 2 kids. That main box is going to spring out 2 smaller boxes, which are going to benefit our kids. And so the trustee can continue to use those batons for those children's benefits until they reach certain ages. So what a trust does is it allows you to avoid probate. It also allows for there to be, basically for things to continue in the status quo. So minimal disruption at death, especially when you have young children. Yeah. And it allows the guardian who would take physical custody of those children to continue to have access to resources to provide care for them. So the 3 main reasons most people create what we call a living trust is to avoid probate, for control, because I can continue to control those batons even after I've died, and then for privacy. The trust document's never filed, so no one actually knows where my assets went. So if those are goals of the client, then I'll suggest that we create a trust.
Okay. So you hit on one thing earlier about the titling of accounts. So I've heard scenarios to where one spouse dies and the surviving spouse is not able to access any cash accounts for a certain amount of time. How would that have been titled? Like, I know it's kind of
sure. It was probably solely in the spouse's name.
So if it was like an individually owned bank account, then that would have to go through.
Would have to go through probate because again, I can't sign on behalf of my spouse. I can't withdraw on behalf of my spouse. Once they pass away, the court is the only entity that can appoint someone to serve over those assets. Which this goes along with that. I get questions all the time. Why can't I use the financial power of attorney? Grandma died, but I'm her attorney. In fact, under the financial power of attorney, the financial power of attorney ceases to have authority at the minute the person died. Right. We have people all the time who try to use power of attorneys after someone has died. Your power is gone at that point because the will takes over, but the court must still appoint the executor under the will before they can go in and access those funds.
So a family who maybe they keep bank accounts separate could fall into that scenario to where one of them's got more money in the other account, and if they die, it's literally you can't touch it.
And even if the wife was the power of attorney on that account while the husband was alive, because she was an owner, as soon as he passes away, she can't touch it.
That's a pretty big deal.
It's a very big deal.
Yeah.
And it's very easily avoidable because you can put a beneficiary on a bank account. So I had one client who had a Christmas account. She was upset that her husband would look at the bank statements and find out what he was getting for Christmas. So she created a bank account and left him off of it. So all we did was we went in and did what's called a payable on death provision or a transfer on death provision and made the husband the beneficiary on the bank account. So if the wife did pass away, that account would automatically transfer to her. To him.
Okay. All right. That makes a lot of sense. Okay. So as we start to kind of wrap this up, is there any one piece of information that you would give to families as they kind of maybe have this conversation initially? Do they need to do anything before they come to see someone in your capacity?
So again, the way I run my practice, then I can't speak for other attorneys. I kind of prefer that they come as a blank slate because we're going to have that educational discussion. Then I'll email them a survey. They can complete the survey and send it back to me. So I think the biggest thing they can do is maybe take account of their assets so that we have a general idea when we're talking what their assets actually are. Sometimes I also give clients, it's just an emergency preparedness guide that I downloaded from the internet, but I give it to them at the end of the process and tell them to keep it with their original will. Every year on their anniversary, pull it back out and update it. It is very hard to serve as an executor nowadays. It's hard to serve as a financial power of attorney because in I'm going to say the old days, but literally 30 years ago, you just watch the mailbox and you know the bills that are coming in, you know the bank statements that are coming in, so you could get a really good idea of someone's finances. It's all electronic now. If I don't have access to my husband's email account, I have no idea the bills that he was paying if he handled all the finances. So doing that emergency preparedness guide, before you come to meet with the attorney is helpful, but it's also very helpful for whoever you are appointing so that they have access and know your passwords for your email accounts so that they know your credit card accounts, especially if you have online-only banking like Ally Bank. Those assets sometimes show up years down the road because people just don't have a good idea of other individuals' financial situations. I'll be honest, I don't think we have a good idea, most Americans, of our financial situations because it's so easy to open a credit card and you sign up for all these things because you get a discount and it gets out of control very quickly.
I completely agree with that. So you mentioned something that kind of makes me want to go down a rabbit hole a little bit, but in this day and age with all the electronic presence that people have, do you see any cases that are starting to pop up where they're trying to shut down like access to certain websites? Like think about the social media websites where if you don't know how to log in, how are you ever going to close it? Mm-hmm. Like what? Do you see any of this stuff yet?
So I haven't seen too much of that. I will say, I think it was in 2017. This is a little bit of a rabbit trail, but South Carolina signed on to what's called the Model Power of Attorney Act. Basically, a bunch of states got together and kind of standardized their financial power of attorney. With that came a new power that I also use in my wills, which is the power to access any digital assets, digital accounts, or digital devices.
Okay, so digital assets like
music.
Okay, airline miles.
Those are a little bit harder.
All right, how do you?
Because those aren't necessarily digital. Those are determined by the contract you sign. I see a lot of Marriott rewards, airline miles with credit cards. So those are governed by the contract that I signed when I opened up that account. But your digital assets, digital devices, again, it's a great power to give people, but that does not mean that the technological overlords are going to make it easy. Yeah. So in that emergency preparedness guide that I give, it actually has you list all your accounts and passwords. And I tell my clients, don't scan it in, don't fill it out on the computer, fill it out in old-fashioned ink and put it with your original will, and then every year update that information on your anniversary. Because again, that's going to be the easiest way for someone to gain access to that information.
That's Pandora's box.
It is. Sure. It is. And sometimes we just let those things go, like the Facebook. Eventually, I think Facebook will deactivate the account if there's been no, I can't think of the right word, but no transactions or updates to the account a certain amount of time. Okay. And I do think Facebook in some circumstances will allow someone else to log in and deactivate it.
Okay. Good. All right. So I'm going to leave it there because I know you got a busy rest of your day. There are two questions that we've asked everyone who has come on this podcast with us. Hopefully they didn't send these to you.
They did not.
All right, so put you on the spot a little bit. Last two things you spent money on.
My husband's going to say Amazon, but it's Christmas time, and I have 2 small children.
Uh-huh. It probably was Amazon then.
Well, it was Chick-fil-A.
Okay.
Because, and I know now I'm giving ad space to Chick-fil-A. No, I am addicted to their iced coffee.
That's okay. You are more than welcome to sponsor us if you would like. You can bring coffee. It's fine.
It was definitely Chick-fil-A. I think the other one would have been my kids' daycare.
Okay. Second one is a little bit more fun. If you could buy anything in the world, what would it be, regardless of cost?
Regardless of cost. See, I would say time, but that doesn't have...
That's the best answer.
I mean, time is just non-existent. No matter how much I try, like I said, I pull my practice back to spend time with my kids, but it's constantly trying to find a good work-life balance. I think a lot of women struggle with that. And even with my husband and what he does, it's trying to find time together as a family.
Yeah,
so
that's fair. All right. Well, give everybody insight on how they can reach out to you if they have questions or want to talk to you in more detail.
Sure. So my law firm is just Ruth Law Firm. That's my first name. Like you said, my last name, DiPasquale. I decided when I started the firm, I did not want to spell that 10 times a day. In fact, I had to spell it out on the phone the other day, and the girl told me, she's like, you've done that a few times. So it's just theruthlawfirm.com. My email address is also very simple. It's just ruth@ruthlawfirm.com. Emailing me is probably the easiest. I actually have a calendar website set up where I can respond with a link to my calendar, and clients can just go on the calendar, find a mutually convenient time, and set up that initial consultation. I never charge for a consultation. And I joke with clients, I don't charge for questions. I do all my work at a flat fee because I want the client to feel like they have time to ask me questions, because again, I want them to understand the process. That's the ultimate goal, because it will be successful if they understand it. So ruth@ruthlawfirm.com.
Perfect. Thank you. Well, thank you for spending time with us and taking time out of your busy schedule.
Sure.
Guys, if you have questions or suggestions for topics that you'd like for us to cover, you can reach out to us directly through our website at fostervictor.com, or you can follow us on Instagram at fostervictor wealth advisors. Thanks again for spending time with us. See you next time. Information contained in this podcast was intended for general use, not to be used as specific advice. For content tailored to your personal situation, please contact one of our wealth coaches.